Thank you, everyone, for signing on to our webinar. We are going to be talking about preparing for the CAP H-1 lottery for fiscal year 2024. I am Miki Matrician. I am a partner at the Boston office of WR Immigration. And I am here with my esteemed colleague, Naveen Bhora, who is a partner at the New York office. So a little bit about our firm. I'm going to change my slide here. At WR Immigration, we specialize in employment-based immigration cases. We have 9 offices across the United States and 1 in Shanghai, China as well. And I'd like to really talk about our technology. So we have an award-winning rapid technology platform. It is proprietary to the firm, and it is built on Salesforce. We combine our high-touch services with this innovative technology, and it's really a huge game changer and a differentiator for us. What makes us different is that we don't just process immigration cases and green cards. We work as an extension of HR and global mobility to strengthen and streamline your immigration programs. Our passion is using technology. We love our dynamic reports, and we use predictive analytics to enhance your and your foreign nationals' experience. And if you aren't already using Rapid, please reach out to us and we can happily give you a demo. One of the things that I wanted to let you know too is that we have a new feature this year in Rapid that allows us to plug in the H-1B registrations, and therefore making it automated and streamlined and even more efficient than usual. And we are one of the first firms to pilot this program. And so WR will use Rapid to feed the registrations into the USCIS portal, and it will basically eliminate human error. We are very proud of this, and it's just one of the examples of how we're constantly evolving and innovating and improving our technology to make experiences better for everybody. Just before we get started, just a little bit of housekeeping. Please note that anything we say during this webinar does not constitute legal advice. If you have any specific questions for your company or for your foreign national employee, please contact us, and we will be happy to discuss with you further. We will accept questions in the end. Please use the Q&A box to throw in your question. With that, I will turn it over to Naveen to give us the overview and the roadmap.
Thank you, Miki, for that introduction. So today we're going to talk about more of the nuts and bolts of the H-1B registration process. Miki will show you some slides with images from what the USCIS account looks like, and walk you through the nuts and bolts of actually registering and what you will see when you're going through the registration process. We'll talk about the registration timelines and some strategy considerations on, identifying individuals who should be going through the H-1B lottery, and then what happens post-selection. So what that process looks like after someone's been selected, and then finally we'll talk about what to do when someone is not selected and what some of those alternatives are to the H-1B. Next slide, please. So first of all, it's really key to identify those individuals who should be part of this lottery. It is a lottery, so the chances aren't that high, so that, wherever possible, you should have your employees participate in the lottery as many times as possible. As an example, if you have someone working on the F1 one-year OPT and they're eligible for a STEM extension for 2 more years, it really does make sense to put them in the lottery as many times as possible, just so that you're maximizing the times, that they can go through this lottery. Also, people who are working on dependent statuses, such as L2s or E3 dependents, they're all work authorized incident to them being in that status. However, their work authorization is wholly dependent on their spouse maintaining their employment. And so as an employer, it's prudent to to have some control over their work authorization and put them on their own H-1B when possible. We have situations where someone's working on L2 status, and then suddenly with this job market, their spouse is no longer employed, and that really puts the company in a bind because their employee is going to be losing work authorization, and oftentimes they don't have much notice either. Once someone's employment is terminated, they have a 60-day grace period, but they're really not supposed to be working during that time. And so just to keep that in mind, that for people who are working on these dependent work visa statuses, it is good to consider putting them in the H-1B lottery and getting them their own H-1s. That also applies to people, who are on TPS or DACA, if it's possible to put them through the H-1B lottery. Some of the TPS work authorization is dependent on USCIS constantly extending TPS status for those countries. And so if suddenly a country is nationals are no longer eligible for TPS, they would also lose their work authorization as well. So again, where possible to have that control over somebody's work authorization, it is good to get them their own H-1B visas. There are also individuals who are already on H-1B, but they're working for what we call CAP exempt institutions. These are universities or government research organizations. They have not been through the H-1B lottery, so they're still subject to that cap, and it's good to put them through the H-1B lottery as well. Next slide, please. Okay, so there is a quota of 65,000 H-1B, numbers per year with that additional 20,000 for graduates of U.S. master's or advanced degree programs. The selection rate historically has been under 30%, so about 26% last year. For people who go through the master's cap, their chances are a little bit better. Maybe closer to 30%, but even then it's not great, which is why we do recommend participating as many times as possible. One of the strategy decisions that we make is, if it's possible to put someone in that master's cap, that's better. So if you have an individual who is going through graduate school right now and will be graduating before June 30th, they're still eligible for that master's cap. So just we ask for a letter from their university registrar or department just confirming that they are expected to receive their degree before June 30th. And based on that, we'll enter them into that master's cap. And then if you have somebody who's still completing their bachelor's program, but they will be graduating before June 30th, they're also eligible for this year's cap. Next slide. Okay, so this is what the timeline looks like. Starting next week, the 21st, USCIS is going to open up the portal to create the account. So please do go through, and if you already have an account from last year, go through and make sure it's accurate and current or up to date. You're able to access it. If this is the first time you are doing the H-1B registration, then please you can go ahead and create that account. And then we will also have our account as well as WR immigration attorneys. And then starting March 1, we're able to create the registration. Once the registration is created, we then send a passcode to the individual company representative, and based on that, they're able to enter that account. They will see first our G28. The G28 is the form that says we're representing you, the company, in this registration application. And then they can see the information that we had entered for each of the individuals. When they approve that, we are then, as the immigration attorney representative, able to go back into our account and complete the registration process, pay that $10 fee, and then the individuals are then submitted in this year's registration lottery. And then at the end, the program will then close on the March 17th. And then for those last 2 weeks, immigration will then run the random computer lottery. And we'll find out by the last week of March, if any of the registrants have been selected. Typically, we get an email, and the company representative receives an email saying you can log back into your account, and there's been an action taken, and then you can see, which cases have been selected. And then we have that 90-day window to actually submit the H-1B petition. Next slide.
Sorry, I had to unmute myself. So like Naveen said, we're going to just show you some nuts and bolts so that you are aware. I know that, this is a once a year event, and so people may have forgotten what it looks like, what to do, or if this is your first time doing the registration, we'll have some screenshots so that you can have a visual. So essentially, these are based on what things looked like last year. And USCIS is holding a webinar February 23rd at 2 p.m. Eastern, and we'll provide any updates. So some of the interface could look differently. We don't know because, they will announce those changes at the webinar. If there are any important updates, we will be sure to blast that information to you afterwards. So now is a good time to sign up. To access your My USCIS account if you have already created an account last year. If you need to create a new one, then that will be possible after February 21st at 12 noon Eastern time. If you're a new HR contact for a company that previously participated, you'll have to also create a new account as well, because the login is specific to the HR contact and not to the company. So let's see. You'll be basically, in order to set up an account, you'll have to have an email address and provide your company's EIN. If you are a signatory for multiple entities, then you have to create an account for each entity with a unique EIN and a unique email address. So please be mindful of that. That would not be necessary if you are filing under one parent entity for a number of different subsidiaries. So please check with your WR attorney to see if that's possible for you. It really depends on a number of factors, so we have to look at everything comprehensively. And so, please check with your WR attorney if you think that it may make sense in your situation to file under the parent entity. Let's see here. One thing to note is that when you set up your account, you will have to agree to set up two-step verification for security purposes, so that each time you sign up with your email and password, you'll be asked to provide a one-time code that you get either from your email if you set it up that way, or through your authentication app, such as Authy or Google Authenticator, and you can get those through your mobile device. One thing that's important to know is that when you go to select an account type, you need to select I am an H-1B registrant. So as the company, you are the registrant. You won't be able to do anything with the account until USCIS opens up that H-1B window on March 1st at noon. But essentially, if you create the wrong type of account, then we'll have to have you delete that previous account and reopen a new in order to make the registration possible. And then once the USCIS opens up the electronic H-1B registration window, WR will register the individuals that you're going to be sponsoring, and you'll need to electronically essentially sign the Form G28 that Naveen mentioned, authorizing us to take action on your behalf. You'll see two options: file a registration or enter representative code. So if you're working with us or an attorney, then click on the enter representative code. You're going to get that from us. And that'll essentially sync your account to ours. And so when we enter the individuals in the account, then you'll be able to see and review and authorize as well. Here's just a snapshot of what it looks like, so that you can review your the information entered on the Form G28 that you can authorize and sign. So this is a screenshot of last year's duplicate submission checker. So essentially, for the CAP H-1B, only one registration per foreign national is allowed for each company. And duplicate registrations are going to be essentially automatically disqualified. And so USCIS instituted this new tool as of last year to help companies to do a double check to make sure there are not duplicate registrations. Of course, we're going to be doing that for you, so you don't need to worry, but that's what this feature is all about. It's important that you make clear to your foreign national employees that they cannot and should not try to register themselves in the lottery, because that will really, that could automatically disqualify them if they tried to create their account and then register themselves. So, it's important to communicate that from the get-go. And something to know too is that if you have multiple entities, you cannot be entering the same foreign national through each of those related entities to try to increase the chances of selection. That is prohibited. And in fact, there's an attestation that is required as part of the process to certify that, not only is this a legitimate job offer that you are sponsoring for this foreign national, but that you also have not worked with and are not agreeing to work with another registrant or petitioner or other agent to submit a registration to unfairly increase the chances of selection for beneficiaries. So please be mindful of that and coordinate internally and with your attorney about this issue. This is what the G28 looks like. And the reason that I wanted to show you this page is because there are options for sending the original notice to your attorney versus to you directly at the company. And we usually recommend that you have it sent to our office. Particularly helpful if you are working remotely and not going into your offices every day. And we have the additional benefit of having our AI bot, Rosie, who processes our government mail for us and instantaneously really makes them available to you. And she works 24/7, unlike humans. So, it's helpful to you and a benefit to you all to use that feature and have the notices sent to us. And so at the bottom of this page, you would submit the G28. Okay, and here is an example of what you would see in terms of the registration summary. And the foreign nationals information would be here as well. And you would have the opportunity to review and authorize the submission. And then you would accept the registration. And that would basically kick it back to us to review the registrations again and make sure that all is in order. We would do the payment for the $10 registration fee and then ultimately click submit. So here is what this would look like on your account for H-1B registrations that are submitted. And you'll see that here there are case numbers associated with each of the submissions. Once the lottery has been registered, and once the lottery has been run, the USCIS accounts will be updated with selections such as this. For cases that are not selected, it'll still show up as submitted. If there were duplicates, which should not happen if you're working with us, it would show up as denied. So for people who are not selected at that initial round, it'll still show up as submitted. And, until all the H-1B numbers are used up and the non-selection notices have come out, it'll still continue to show up as submitted. Last year in 2022, USCIS did use up all of the H-1B numbers when they announced the lottery selections at the end of March. The year before that, they hadn't quite figured it out, and so they had to have 3 drawings to use up all of the numbers. They had a drawing in March, and then July, and then another one in the fall in November. Hopefully this year they have figured it out based on their experiences last year, and will finish up all of the selections in one go. Okay, I'll turn it over to you. Oh, sorry, I may have skipped it. Okay. I'm going to turn it over to you, Naveen, about what happens next when somebody is selected.
Thank you, Miki. So, depending on, how your case was prepared for your individual, some of our clients, we do all the analysis and the labor condition application preparation ahead of time during this month of registration. So as soon as we know the individual has been selected, we're able to finalize the H-1B documents and file the petition within the month of April, as an example, because the LCA and everything has already been done. For others where we're just doing the registration and we're going to then wait for a selection, the next part would be to prepare the labor condition application, send that to the company for posting, get that certification done, the labor condition application certification completed, and then we would finalize the H-1B documents and submit the H-1B petition with USCIS. As I had mentioned before, if the individual beneficiary, we're waiting for them to complete their degree, we will then wait for May or June once they have completed their degree, and then file the petition at that point. We do have until June 30th to actually file the petition. And then we will receive all the receipt notices, and our bot Rosie will send notices on the receipts. And then of course, when the case is approved, or if we get a request for evidence, we'll keep the company and the individual beneficiary, apprised of what's going on with their case. Next slide, please. Okay, so when we are preparing this filing, the H-1B petition itself, one of the big discussions that we have with the individual and the company is whether or not we're going to be requesting a change of status with the H-1B petition, or it would be noted for consular processing. The change of status means that when the petition is approved, you'll receive a receipt, an approval notice, that Form I-797 that has the I-94 attached to the bottom, and it indicates that automatically on October 1, the beneficiary status will convert to H-1B, and they don't need to take any more action to activate their H-1B status. And the change of status is actually really great for people who, it could be difficult to travel back to their home country to get a visa. Right now, it can still be a challenge getting a visa appointment at a U.S. consulate. So if there's a lot of uncertainty there, certainly it's better to just stay in the United States and apply for that change of status. For people who are on OPT and their OPT work authorization is going to be expiring over the summer, and they need that cap-gap extension, which Miki is going to go into a little bit more detail about. For those folks, it does make sense to do the change of status. Just to keep in mind that for change of status, you do need to be physically in the United States when we file the petition. The individual can be abroad when the registration happens, but for the change of status filing, they need to be in the United States when the petition is submitted. So between April and June, when the application is submitted, they do need to be back in the U.S. Also, once the petition is filed and it's pending, or up until October 1st, they should not travel. So if there are international travel plans or they know they're going to be abroad during the summer, then the consular notification is the way to go. So consular notification means that the petition will be approved with an October 1 start date, but the person's status won't actually activate. Their H-1B time and status won't activate until they go to the U.S. consulate, they get the H visa stamp or sticker in their passport, and they re-enter the United States with that visa. If they're Canadian, it's just a matter of going back to Canada and re-entering with the H-1B approval notice at the port of entry or through pre-flight inspection. For people who want to maximize their work authorization, the time they have on their OPT, and postpone the clock of their 6 years of H-1B time, some of those folks actually prefer the consular notification so that they can stay on OPT longer. And then it's on them to travel back home before their OPT expires, get the visa, and then come back to the U.S. As a reminder, there is a 6-year limit of H-1B time, and so for some people, that's important to use up all of their OPT time before they use up their H-1B time. Okay, next slide, please.
Okay, so I will address what is cap-gap protection. So, for F1 holders, if they have an EAD that expires after April 1st, 2023, and they're selected in the lottery, there's a special provision in the law that bridges the gap between the expiration of their EAD to September 30th, 2023. And then basically what happens is that the selected H-1B the F1 folks can go to their school and let them know that they were selected in the lottery and get an I-20 that specifically authorizes the extension of their EAD all the way through September 30th. And this is only available if the individual is filed under change of status. It is not available if the individual is filing under consular notification. So that is one of the considerations, as Naveen mentioned, in strategizing the case. Also really important to know that you cannot travel internationally unless there are narrow exceptions, but in general, you should avoid international travel for people who are benefiting from cap-gap protection. The other thing to know too is that cap-gap is good only until September 30th. And so if the case is issued a request for evidence, for example, your F1 employee could run out of work authorization under the cap-gap. So it may be important to consider using premium processing for those employees so that they can get the decision and the approval before September 30th to avoid a gap. So what happens if someone is not selected in the lottery? What does it mean? It does not mean that the case was denied or refused. It really just means that the individual's name was not selected in that randomized computer-generated lottery. There's no negative impact to your ability to sponsor the employee in the future or for them to pursue other options for immigration benefit. And for people who are not selected, we would normally recommend working with your attorney to plan ahead of time to identify those people that sort of are in their last chance at the lottery without a break in work authorization, and to plan out what alternative options might be available. So we're going to be talking about this next, but we're constantly working with our company clients to think about this even before the lottery results come out so that the business can explore internal approvals for those options, and that could include sponsoring them at your entity abroad, and we can help with those cross-border non-US destinations as well. So before we turn to all of the alternative options, here's just a recap and a summary of what your next steps are. So now is really the time to shore up all of your employees that you're going to enter into the lottery. Make sure you've captured anybody who are new hires or new candidates that you've extended offers to that were not on your original cap list, and make sure that your attorney has those last minute additions. And for companies who are new to WR, we're still accepting new cases, so please get in touch with us. And Naveen, I'll turn it over to you to address some of the alternatives.
Yeah, thank you, Miki. So the first one is, as I mentioned before, there are people who are able to have H-1B status without going through the lottery, and they're working for institutions that are considered cap exempt. And so those are the universities or affiliated with universities, government research entities, and nonprofit research institutions. So those folks can certainly look for jobs at one of these institutions, and they can continue their work in the United States. It's also possible for someone who's working for a private company to be considered cap exempt if they are working at one of these institutions. So, for example, if you have a company that's involved in research and they are actually physically located at a university lab, then they could potentially be cap exempt as well. There needs to be some type of an affiliation with that institution. People in healthcare, if they're at a teaching hospital where there is an affiliation with a medical school, those institutions can also be considered cap exempt, and you could get an H-1B in those circumstances. You could also do a concurrent H-1B where somebody has a part-time H-1 with a cap exempt institution, and then those folks can also get a concurrent H-1B with a cap subject company. So a private company can hire someone who is maintaining H-1B at a cap exempt institution, but just to keep in mind that they must maintain their employment and their H-1B status with that cap exempt institution for them to continue with the H-1B with the cap subject company. Next slide. Okay, now the free trade agreement. So there are a few different options for people who are citizens of certain countries where there's a free trade agreement. And so these people can get work authorization separate from the H-1B. There is particularly the Chileans and the Singaporeans, they have a specific H-1B1 category. It's very similar to the H-1B, but they have a different quota, and the quota is never reached. So it's always available, and they can apply year round. Similar to the H-1B, there is an LCA requirement with a prevailing wage obligation. And so if your individual is from one of these countries, then they can always do the H-1B1. E3s are similar in that it's also a specialty occupation with an LCA requirement, but it is limited to Australians. The TN is for Canadians and Mexicans, but it is a very limited list of professions that qualify for the TN. And for all of these free trade agreement-based visas, you can bypass immigration, bypass USCIS, and apply directly at the U.S. consulate, or if you're Canadian, you can apply directly at the port of entry. So it's a great option. And when you're identifying individuals, who would go through the H-1B lottery, sometimes it just makes more sense to do the E3 for them instead. And the E1 and E2 for the treaty traders and investors, there must be a trade agreement between the U.S. and that country. So we would just have to double check that that there is in fact a treaty in place. And then also the company needs to be majority owned by nationals of that treaty country. Next slide. Okay, now the O1 is for people who are at the very top of their field. It's it's known as like the Einstein visa, but you don't have to be Einstein to qualify. You just have to meet 3 of the criteria. And the O1 is also outside of the H-1B lottery. It's a great work visa to have if you have an individual who qualifies. We have found that this is more successful for people who are in the sciences, for example. Having gone through PhDs, they tend to be more published and can, meet some of these criteria more easily. Or people in the arts, for business, it's also possible. But again, you have to show that you are at the very top of your field and have the evidence to support the national or international renown. So, that there are articles about you or your work, that you've played a critical role for commercially successful enterprises or ventures, that there's articles about you, you've received awards. So if you can meet those standards, then certainly the O1 may be a great visa option. Also, just we hadn't mentioned this earlier, but if you have an individual who was on a J1 visa, which is a trainee visa, and some of those folks are subject to a 2-year home residence requirement because they had a grant, for example, from the U.S. government or their home government, such as like a Fulbright, they actually cannot get an H-1B visa until they've received a waiver of that 2-year home residence requirement, or they've actually gone home for 2 years. So for those individuals, the O1 might be the better option because you can actually get an O1 visa without having to first obtain that waiver. So the O1, is available, and you don't have to be an Einstein to get it. Next slide, please.
Thanks, Naveen. And I can address the L. But for all of these options, our attorneys are going to strategize with you and assess whether somebody is eligible for this visa or that visa. If someone looks like maybe they could be eligible for an O1, those are things that we'll be strategizing with you. So an L1 visa may be a good option for your employee who previously was employed at a related entity abroad. So either the parent company, if it's based abroad, or an affiliate or subsidiary. And there's two kinds of categories under the L1. It's the L1A for those people who were employed in a managerial or executive capacity for a year or more, or L1B for specialized knowledge workers. And those are people who have knowledge that is specific to the company. And really for the L1B, it's really important to be able to show that they have a level of specialty or expertise that's not really easy to find outside of the company, and that the company has spent a lot of time training these individuals. And so it doesn't make sense to have to hire a U.S. worker for this category. So if you do have somebody that was employed at your related entity abroad for 1 year, and that person is working for you in an executive, or going to be working for you in an executive or managerial capacity in the United States, or specialized knowledge capacity, then this may be an option for you. Okay. So some employees may decide to go back to school, right? I mean, they may have a bachelor's degree in a particular field, and they may now want to pursue a master's degree and enhance their career. It's important to know that in order to pursue F1 curricular practical training as a work authorization, there really does have to be this desire to attend school full time. So what these individuals would be doing is balancing full-time school, and if they're going to continue to work for you, that they understand that they have to balance both. And of course, there's tuition and payments involved, in actual attending, doing homework and projects and all of that. So the employee has to be ready for that and accept that as the situation here. Some schools may allow people to work while attending school, and that's what the curricular practical training is about. But not all programs are eligible for this. It's really specific to the program of study, and it's dependent on the school to determine if that program of study is eligible for curricular practical training. And so it's really incumbent on the foreign national employee to do that research and figure out what programs they do have interest in attending and paying for that tuition and continuing to work for you. The role that they want to continue to work for you in has to be related to the program of study. That's really important, and that's key to having the school approve that curricular training opportunity at your company to continue the work. Some schools do grant immediate curricular practical training known as day one CPT, so that they can go from their current OPT, for example, to re-enrolling in school and continuing to work with minimal gaps in work authorization. There are a lot of factors here, though, and so it's really important that you work closely with your attorney to plan out not only the timeline for switching from their existing status and work authorization to curricular practical training. There's also coordination that has to happen with the SEVIS, the records that the schools maintain. So there may be some minimal gaps in work authorization, even if they're trying to go from the end of OPT to CPT. There's also something that's important to consider is that depending on the administration that is in power at that time, USCIS has in the past questioned whether an individual was properly maintaining their F1 status if they had gone from F1 OPT or STEM OPT to then CPT as a result of not being selected in the lottery. And so it is not without risk. Currently, in this administration, we haven't seen too many issues with that maintenance of status, but we do always advise that foreign nationals maintain a folder, a file where they can keep all of their records to show that they were in fact maintaining valid F1 status. And those things include, evidence that they have attended classes, evidence that they've completed their assignments, and that they're progressing through their program of study. And then finally, it may be possible for foreign national individuals to jump straight to the green card process. Some categories do require employer sponsorship, like the firm-based or outstanding researcher-based green card case. There are self-petition options that your employees might want to explore as well, and those are the EB-1A, which is sort of the green card analog to the O-1 visa that Naveen was discussing. There's also the national interest waiver, which really, not available for all fields, but for some that you can show that their work is in the national interest. And then, of course, never overlook the possibility of a family-based petition. If your employee has a U.S. citizen partner, that might open up a green card path if they're planning to get married in the near future. So that is something that we always explore as well. With going from something like an F1 or TN or H-1B1 or E3 visa, those are really visas that are specifically requiring non-immigrant intent. And so it really becomes important to discuss in detail with your attorney about immigrant intent issues, timing of when you file these cases, and if there is international travel that your employee is contemplating, that all of that is factored in holistically to the strategy. So we'd like to now open up to questions. If anybody would like to throw your question into the Q&A box.
Thanks, Miki. So while we're waiting for questions, perhaps if you could talk about what the timings look like right now for the green card processes through PERM or premium processing, where those are available.
Sure. So processing for green cards really do depend on where you were born. So if you were born in a country that has a current backlog, then the green card processes can last anywhere between 5 years to 10 years. But there are special, categories that may not be backlogged. So it's really something that you should explore with your attorney. But for perm-based cases, for non-backlog people, it might be a viable option. perm cases are taking longer than they were in sort of recent history. The first step of the process is taking about 9+ months now. That's the prevailing wage. That's the really first step of the 3-part process for the perm. The I-140s is the second step, and that is eligible for premium processing. And the third step of the process, the I-485, that's the process that will get you the work authorization that you need in order to bridge any gap between your current work authorization and the green card work authorization. That will take anywhere between 3 and 12 months right now. So USCIS is quite backlogged in processing those types of applications. And then, as I mentioned, the Department of Labor for the first step is pretty backlogged as well. So while the green card options are a good thing to consider, it is important to keep the timing in mind and how much time you have available in your current non-immigrant work authorization.
Thank you. So we have some questions. The first one is the turnaround time for H-1B. So for this one, if you do premium processing, the case should be reviewed within the 15 calendar days. With regular processing, it can take 2 or 3 months. That's what we're seeing right now. Typically, the processing times take longer during this time of year because they just receive so many cases. But if you do premium processing, it would be that 2-week turnaround. The E2 processing times, so those are done at the consulate, and it just depends on each of the consular posts what their timings are. Sometimes you file the petition directly with the consulate. It may take them 2 or 3 months to review the application and then call the applicant in for the interview. South Africa does not have a backlog on the immigrant visa numbers. Those are really individuals from India, China, who are affected by that country quota. South Africa does not have a treaty, so the E2 or the E1 is not available.
There's a question about 15 days from when, and I assume that's referring to premium processing. So the premium processing timelines are 15 calendar days at the moment, and 15 days basically from the time that USCIS has issued the receipt notice. So if you have a receipt notice, it's 15 days from that notice date. There is a question about asking for more information about the national interest waiver. Naveen, do you want to take that?
Sure. So this one is for people who have an advanced degree and they can argue that their work is in the national interest. You can actually self-petition, so you don't need the company to sponsor you for this green card category. But it is similar to the extraordinary ability in that it is a very document-heavy filing, and it's subjective. So it's up to the immigration officer if they believe that your work really is in the national interest. Historically, the national interest waiver petitions were taking well over a year for adjudication, but this year they are opening it up to premium processing. So that's great. It does fall in that EB2 category. So within the employment-based green card categories, there are 5. The extraordinary ability outstanding researchers, which Miki had gone over, those are the first preference categories. NIW actually falls under EB2, which is second preference. And for Indian and Chinese born nationals, that is a backlogged category. So you can go through, file the petition, but it will still take a really long time for the immigrant visa to become available.
Yeah, and under the Biden administration, there is a push for supporting cases or supporting people in the STEM fields. And so if you're working in the STEM fields, the NIW is definitely worth looking into. And by all means, all of the options that we had discussed are not, not comprehensive, right? So there may be other options available, but we did go over the options that we see sort of most commonly that are employer sponsored. And I think we have covered all of the questions. So thank you, everybody, for attending the webinar today. And if you have any questions, please feel free to be in touch with us. Here is our information on how to contact us, and we look forward to hearing from you. Thank you very much.
Thank you.